Good evening, everyone. My name is Arinda Chutta. I'm an associate Marshall. Thank you for joining our webinar tonight. I'm still waiting for my other panelist, Andrew. He's just having some trouble logging in, but I'm going to start in the meantime. Okay, just put everything on. So tonight we're going to speak about communication regulations, and we're going to talk about misinformation and fake news on COVID-19, as well as a bit of social media in general. So feel free to use the chat function and ask any questions if you have any, and we can address that as we go on or towards the end, especially if you have general social media questions that we are not talking about in this webinar. So as we all know by now, as a result of the COVID-19 pandemic, South Africa was declared a national state of disaster in terms of the Disaster Management Act on 15 March 2020. On 18 March, the regulations to the Act were gazetted that sets out the steps that we as a country should take to prevent the escalation of the disaster or to contain or minimize the effects thereof. These regulations have changed and have been updated quite a lot over the lockdown period and the level 4, and is going to change again now going into level 3. So if we talk about misinformation and fake news on COVID-19, the government has essentially introduced a temporary criminal offense to fight fake news about the coronavirus. Initially, this was found in Regulation 11.5 of the regulations. It's now covered under Regulation 14.2 under offenses. The spread of the fake news and misinformation around corona has been flooding social media, and it will have a dire impact on preventing the spread of the virus in South Africa because it creates a general confusion. Various of these fake messages and voice notes about COVID-19 have spread quickly across WhatsApp groups and other social media platforms. And these false messages have been shared both in person-to-person messages, but probably more concerning because of the fast spread via WhatsApp groups. So before I jump into the regulations, my fellow panelist has joined me. Andrew.
Hello, everyone. We're an ICT law firm, but we sometimes have our battles with ICT. So Arinda's introduced herself. She's an associate at a firm. My name is Andrew Marshall. I'm a director. I head up the ICT law side of things. We haven't had as much of an interesting time as our colleagues in this COVID situation, but we muscled our way in. It wasn't fair that all the others got all the attention, so we felt it would be best if our department made our small contribution to the discussion around this area. We're going to be discussing the electronic communication regulations. We're going to be discussing the track and trace regulations, which allows people to see where you are and who you've been associating yourselves with. Arinda has started off with dealing with fake news and COVID and a bit on social media as well as it relates to COVID. If you have any questions for us, you can, I believe you can ask the question through the chat facility, and we will see them and we will answer them unless you don't know the answer, in which case we will ignore you. Only kidding, no one. I also on some further housekeeping that I noticed that the new level 3 regulations have just come out, and our litigation department is, as we speak, hard at work in preparing the next webinar, which will be in the next few days, which will give our thoughts on that. So, Arinda, if you want to carry on, go ahead.
Thank you, Andrew. So, if we actually start discussing the actual regulation that covers the misinformation and the fake news, it basically sets out that fake news and other forms of misinformation about COVID or about someone's infection status or the specific measures that government are taking are prohibited. So this means the publication must be with the intention to deceive people. That is the limit here. It also makes reference to any medium, which would include SMSs, WhatsApp, Twitter, Facebook, Instagram, anything online, networking, or social media platforms. So it basically includes information posted or published on any of these platforms. At the end of the day, the state has to prove that you published the statement with the intention to deceive. This means that you had to publish it knowing that it is false and with the intention to mislead or deceive other people to believe what you believe is this false information. It will be quite hard to prove this from the state side, but I don't think it's worth taking the risk to see if you're actually going to be convicted. So rather just stay away completely from posting any false information or made up information that you believe. And if you see something, rather fact check it before you start posting it. And this goes for sharing as well. The offense of spreading fake news is also not conditional on you being the creator of this fake message. In our law, it's the general rule that the sharer is as guilty as the creator. So you need to be extremely careful when you are forwarding those WhatsApp messages to your friends and family and on the WhatsApp groups. And be careful of sharing things on Facebook without checking the validity of the information. Also remember that the line between personal and work life has faded a lot with the use of social media. There's no more in my personal capacity for professionals. Professionals are associated with employers in the online space, which means as soon as someone says something in their personal capacity, like Vicky Momberg, Adam Cancevelos, the late Penny Sparrow, immediately the company the person works for is tagged in that post, or they get emails, they get messages, and the public wants to see action being taken by the employer. So if you do a quick Google search, you will find numerous examples of people being fired or the employers taking disciplinary action against them for something they did online that put the employer in a bad light. Because remember, you always have to have your employer's best interests at heart. You should also remember that as an admin or the owner or the creator of a WhatsApp or Facebook group, you may be held responsible for the content that is posted to that group. It's important that you as an admin should consistently monitor the content being uploaded. WhatsApp or Facebook group admins must take steps to ensure that the platform is not abused. And this includes having your group guidelines, pinning it to the top, removing people that don't play by your rules that you've set out. And you need to correct fake news as soon as possible or remove the content that is that is defamatory, harassment, hate speech, anything that is not supposed to be on your platform. You need to remove that, and you need to constantly educate the members of your group. Technically, the admin would only be responsible for content on the group if they themselves posted the material or if they encouraged the posting of the material and took no steps to limit the effect of it. So we've seen a trend of cigarettes and alcohol being sold over WhatsApp and Facebook groups during the lockdown when it was illegal to do so. And as the admin of a group like this, you can be held vicariously liable for the illegal cigarette and alcohol sales on your platform if you don't stop it or if you encourage it. And this remains relevant in our everyday non-corona related lives as well. By consistently allowing commentary on your platform, either WhatsApp or Facebook or whatever platform you have, if this content is defamatory or harassing or amounts to hate speech, you are effectively condoning it and creating a platform and an online environment where this type of content is allowed to flourish. And there is case law on this in South Africa, for example, the SA Human Rights Commission versus Sunette Bridges, where Sunette Bridges was held liable for the comments being made on the Facebook page that she owned as a fan page. And she was ordered to remove all the discriminatory posts and post a public apology. And she was always also asked to monitor her page going forward. And every time she sees something that's not supposed to be there, she has to effectively go and take it off. And that's what is expected of you as the admin or the owner of a group. So if we look at the enforcement of how they are enforcing these regulations on fake news and misinformation, the regulations allow for a wide range of telecommunication players to have the responsibility to remove fake news related to COVID from the platforms immediately after it is identified as such. So this list of providers with this responsibility includes internet service providers and over-the-top communication providers like, for instance, WhatsApp. And a high-tech monitoring and evaluation process has been put in place by government to assess complaints and reports from the media, from the public, and other sectors of society. with the ability to then take down fake news items on a range of platforms and submit cases to the police service for investigation and prosecution. This solution is a unique collaboration between the Government Communication and Information System, Media Monitoring Africa, and the COVID Communications Volunteer Group. It forms part of the work of a special ministerial task team established by the Department of Communications, which also includes representatives from ICASA, the Film and Publications Board, the ZA Domain Name Authority, all the mobile phone operators, and other key players in the ICT sector. So once fake news items or social media posts has been identified as fake news or misinformation, the platform owners are notified to bring down the post. Electronic communication services licensees, including the OTTs and the ISPs, will then have the responsibility to remove the fake news from the platforms with immediate effect. So we've already seen some of this happening. WhatsApp is limiting the amount of people that you can forward a message to, just to curb the spread of information. And Facebook is also flagging certain words that you use in posts and taking it down immediately. Also, remember that you can always report content directly to Facebook, but at the moment they are super busy dealing with this type of thing. I actually tried to report something during the week and it immediately brought up a pop-up saying Facebook is busy with COVID reports. So if your report is not urgent, don't submit it. So I'm assuming they're getting a lot of reports and flagging. The general public can also report fake news through the Real 411 website. That's www.real411.org. That's a government website. Or you can use the government WhatsApp line that they set up. I will post the number in the comment section later on. You can also report hate speech or content that incites violence on this Real 411 website. And there's also an updated list of articles that debunks some of the fake news going around. So it's definitely worth checking out, especially if you want to check the information that you're posting. So enforcement is as easy as you taking a screenshot if you see something and sending it to the WhatsApp line or posting it on the Real 411 website or going to your local police station to make a case, and they will need to investigate it. I can't tell you if it will work everywhere or how effective it's going to be. But if you are found guilty, you can get a 5,000 Rand fine or imprisonment for up to 6 months. So that's a big risk to take to post something on social media. At the moment, there's no case law yet on fake news, but there are a few examples that we can just check. Recently, a Cape Town man was arrested after recording himself during a gathering of more than 100 people. And he was making fun of the efforts to contain COVID-19. He was basically saying, nothing called Corona is here in South Africa. And after posting that, he was investigated and he was arrested. There was also a post going around falsely claiming that all citizens must fill out forms before leaving their homes to go grocery shopping. That was something that was happening somewhere overseas. It was not South Africa related. And the person who steered this lie is now facing criminal charges. The last example was a video widely circulated on social media, which you probably saw, of a paraman claiming that the medical swabs used by health workers during community screenings are contaminated already with Corona. So he was also arrested and charged with breaching the Disaster Act. So it is clear that these regulations are actually being enforced strictly, and now more than ever, you need to verify all the information before you share it or post it on social media. Not only because it's an offense now to share false information about COVID, but because each of us should be informed and act ethically in these times and stand together to fight the virus and not cause panic or general confusion. You need to assume that everything you read is false until proven otherwise, and you need to go and investigate before you post or share on social media. Always remember to think before you post. Emotions are running high now, and everyone is using social media as an outlet for their frustrations and their opinions. But don't get into a political or other debate on social media. It's not the place for it. The comment section is a trap. It fuels the fire, and I can promise you that the comment you posted in the heat of the moment will be screenshotted and shared with your employer or pop up on the internet when your future boss Googles you when they receive your CV. Remember that social media doesn't have context. Remember that social media does not have context. So your comment might be 1 in 1,000 or a legitimate answer to another post or comment. But if it's screenshotted on its own without any context, it might send a completely different message. So always think about how is someone else reading your comment from the other side of the screen going to interpret it. Just because this is the way you think it says something doesn't mean that someone else will see it in the same light. We always use the quote, what happens in Vegas stays in Vegas, but what happens on social media stays on Google forever. Be mindful of the digital footprint that you're creating for yourself online by posting constantly. And consider whether the information you put on the internet is a true reflection of you or who you want to be in life or how you want other people to perceive you. Do a quick Google search on yourself and just see what pops up. And that would give you a good idea of what you already have on the internet. We all have the right to freedom of our opinion, freedom of our expression, but remember that these rights can be and are limited. You can't infringe on someone else's right for your right to freedom of your right of expression. Be careful that you don't defame or harass people on social media or use hate speech. It will land you in legal hot water and it can have serious consequences like an interdict against your name or a multi-million damages claim. Probably not multi-million, but a proper damages claim. We all have the right to privacy and the right to not be defamed or harassed on social media. Don't do something on social media that you don't want to happen to you. So always be careful, especially now during this corona situation. Be mindful of what you're saying or doing on social media and be mindful that it's always going to stay there, and be very mindful that it is now an offense and you can go to jail or be arrested or get a fine for your actions. Thank you. Andrew, you can now take over.
Thanks, Rinda. Well, I was going to speak first, but Rinda got in there first. So I had to play second fiddle. So I'm going to be speaking about the communications regs. I do overlap slightly with what Rinda had to say, but not very much. The electronic communications, postal and broadcasting directions are essentially regulation under the main regulations. They are mainly directed at communication service providers and broadcasters to assist with COVID control. Most of them relate only to those parties, but there are a few regulations which have a more general interest. First of all, the regulations dealing with fake news, which Arinda's covered, so I won't double up on that. Then the intention seems to be that everyone with the .co.za domain name has a little link to the government's COVID website. So what it says is that all internet sites within the .za DNA top level domain must include a link to this website. Which doesn't make a great deal of sense because there's no such thing as a .za DNA top level domain. There's a .za top level domain, certainly. So I think what they mean is all websites with domains in the second level under .za, so .co is a .org, .za, .net, .za, and so on and so forth. And also, of course, the regulations don't apply to regular businesses and individuals. They only apply to telecoms people and also to regular people only insofar as a telecoms provider wants to come and dig up your lawn to lay a cable. Otherwise, it doesn't apply. So I don't know why they put it in here, but it's for a good cause. That is the intention. The intention is there. We should all do our part, I suppose. And so if you do have a .za domain and you run a website off it, then you should have that link on it, just to be nice to them. Then there's service providers are obliged to give 0 rating of content to certain local education websites. The idea is to assist with distance learning. Obviously, people, children and students can't or couldn't go to school and university, and so the idea here was to make access to those materials cheaper and easier. The trouble, of course, is that many education websites aren't local. So Khan Academy, YouTube, and so on and so forth, they aren't local domains, and so they aren't. That this hasn't been much help in that respect. That's been the experience of the people in education that I've spoken to about this. Then in the health sector, again, there must be 0 rating of COVID-related sites identified by the Department of Health and a 0 rating of calls to the national COVID number. Right, I'm just going to check if there are any questions so far on that. So that's the aspects of those directions which kind of relate to most of us, or which we would find interesting. The main course though is in the main regulations, and it's called contact tracing, or track and trace is the regular name for it. The idea is that a database is set up which allows the DG of health to trace people through their cell phone numbers who have or may be positive with COVID, and also to trace people who have or may have been in contact with that person, and therefore to try and keep a lid on the further spread of COVID. Now, the database is established in terms of these regulations, and what can be collected is names, obviously, ID and passport numbers, residential addresses, other addresses where persons could be located potentially, cell phones, obviously, for all people who have been tested, the COVID test results, and the same details of people who have been in contact with tested persons. This obviously has a huge, there are obviously huge privacy implications for this, and so the regulations are quite carefully drafted, I feel, to assuage people's concerns in this regard. It's made clear that the database is confidential. Information in it will not be disclosed unless it is that disclosure is authorized, presumably by the minister or the DG of health, and that the disclosure is necessary for preventing the spread of COVID. How it's collected is quite interesting. At the testing stage, if you're going in to be tested, it's supposed to collect your name, address, ID number, cell phone number, and a copy of your ID document, as well as information on anyone you've been in contact with. Now that's then sent off to the DG of Health. The laboratory which then processes that test sends the same information plus the result. The National Institute of Communicable Diseases, insofar as they have any information, sends the same information through, plus the result, plus information on any people who've been in contact. And interestingly enough, any accommodation establishments, by which I assume they mean hotels, B&Bs and such, where people have been staying during the lockdown, have to submit the same information to the database. So you then have this database, this ever-growing database of the people who've been tested and their results. We then move onto tracing. If we require a trace, the Director General of Health can request a telecoms provider for information on the location or movements of a person who has contracted or is reasonably suspected to have contracted COVID, and the same information on anyone who is suspected to have been in contact with that person. And this is quite important. This request is done without the prior notice of any of the people concerned. So obviously the privacy issues, which brings us onto the next part, which is oversight. How do you make sure that this isn't abused? Now, there's several rules put in place. First of all, the tracing info itself, so not the PC database, but the results of tracing inquiries based upon that database, they can only be used until the end of the state of disaster. They can only be used if authorized for the purposes of combating COVID, again, authorized by the minister or the DG, or one would assume. And they can only be retained for 6 weeks after the result was obtained. A judge is overseeing all of this, and an ex-constitutional court judge, as I recall, it's Kate Reagan, who is highly regarded. The DG is to prepare a weekly report to be filed with the judge, and the judge can make recommendations to the Minister of Cooperative Governance and Traditional Affairs relating to the amendment or enforcement of these regulations. The important part, of course, is what to do with all this information once Armageddon is over. All this information must be disposed of within 6 weeks after the national state of disaster has lapsed. By all this information, I mean the information in the database, not the tracing information, which they can only keep for 6 weeks anyway. At this point, within 6 weeks after the disaster has lapsed, the DG of Health must inform all people who were traced that they were traced. The data in the database must be de-identified, but that de-identified data can be used for research, study, and so on and so forth. Now, de-identified means basically that you strip off any personally identifiable information, so you can't relate a particular record directly or indirectly to a particular person, and they can use that for research, which is fine. If they can't de-identify it, then it must be destroyed. Interestingly enough, even though POPI hasn't yet come into force, there's a provision in POPI section 6.1b, I think it is, which says that POPI doesn't apply to the processing of information in these kind of public emergency situations unless there's adequate provision, or rather, as long as there's adequate provision made to protect the privacy of that data. And as you can see, there are steps taken. Whether they are adequate or not is another matter to protect that privacy of the data. So yes, those are the regulations insofar as they relate to ICT. Are there any questions?
Doesn't look like there's any questions at the moment.
Doesn't look like it. All right. Well, if anybody's shy and they don't want to type up a question, feel free to drop us a line afterwards, and we will be most obliging to get back to you on it. The privacy aspects are quite interesting, and we're going to see what happens afterwards when people start getting excited about the fact that they were traced and didn't know that they were traced. But that'll be fun and games in a few weeks' time. All right. So
if you don't want to be too formal, you can send us a DM on our Instagram page. It's DM_social_. You can just pop us a message there. There's also a lot of information on there.
Right. Well, thank you for listening. I hope you enjoyed it, and we will post a link to the recording of this webinar if you want to relish my turn of phrase once again. And have a good evening, and we'll see you next time. Bye.
Thank you. Bye.